This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the waiver of a right to appeal and why it will be effective, and why an insurance agent who defrauded her clients by taking premium money and keeping it for her personal expenses found it appropriate to plead guilty. When a criminal defendant's valid guilty plea includes a waiver of the right to appeal, the Fourth Circuit Court of Appeals generally enforces the waiver by dismissing any subsequent appeal that raises issues within the scope of the waiver. However, even if an appeal waiver is valid and applicable, the Fourth Circuit will review a claim that a district court's sentence or restitution order is excess of the court's statutory authority. And that's what they did in United States of America versus Glenda Taylor-Sanders, a U.S. Court of Appeals for the Fourth Circuit decision made on December 12, 2023, where the defendant sought a change of her sentence and restitution order. From February of 2017 through May of 2019, Taylor-Sanders took advantage of her role as a licensed insurance agent to defraud several trucking companies and the insurance finance company Bank Direct Capital Finance. She defrauded the trucking companies by misappropriating funds that the companies provided her to pay for their insurance policy premiums, and Bank Direct Capital Finance by obtaining loans under the guise of a non-existent insurance policy. Instead of using the funds she obtained to pay insurance policy premiums or pay back Bank Direct Capital Finance for the legitimate loans it made to the trucking companies, Taylor-Sanders spent the funds on personal expenditures, including cars, football tickets, and mortgage payments. Predictably, some of the trucking companies' insurance policies lapsed because Taylor-Sanders did not pay the insurance premiums. Her scheme unraveled when one trucking company, DW Express, discovered its insurance policy was canceled for non-payment after it tried to file a claim for an April 2019 trucking accident. Taylor-Sanders signed a plea agreement under which she agreed to plead guilty to one count of wire fraud. She also agreed to pay full restitution regardless of the resulting loss amount to all victims directly or indirectly harmed by her relevant conduct, including conduct pertaining to any dismissed counts or uncharged conduct, regardless of whether such conduct constituted an offense, and she waived all rights to contest the conviction and sentence in any appeal on any grounds other than ineffective assistance of counsel or prosecutorial misconduct. In exchange, the government agreed to dismiss all the remaining counts against her. On January 24, 2020, Magistrate Judge David C. Kiesler conducted a plea hearing pursuant to Rule 11 of the Federal Rules of Criminal Procedure. After two adjournments to further explain the plea to her, Taylor-Sanders confirmed that she intended to plead guilty, understood that the decision to plead guilty was entirely hers, and had an adequate opportunity to review the plea documents and discuss possible defenses with counsel. She confirmed that she understood and agreed with the plea documents, that no one had threatened, intimidated, or forced her to enter the guilty plea, and that she understood all parts of the proceeding. She also confirmed that she was satisfied with her counsel's services, had no further questions or statements, and still wished to plead guilty. After this colloquy, the magistrate judge found that Taylor-Sanders' plea was knowing and voluntary, and that Taylor-Sanders understood the charges and potential penalties and consequences of her plea. 4 months later, Taylor-Sanders moved to withdraw her guilty plea, asserting she was told she had no choice but to plead guilty and that her plea was not knowing and voluntary because she did not fully understand the interplay between her guideline range could be versus the final sentence. The district court found that the government witnesses were credible, that the documents it submitted were consistent with the factual basis document and pre-sentence investigation report, and that the evidence overwhelmingly established a factual basis for Taylor-Sanders' guilty plea. In contrast, the district court found that Taylor-Sanders' testimony was not credible, noting Taylor-Sanders was thoroughly impeached by her prior misstatements in other areas. The district court further found that Taylor-Sanders had engaged in a pattern of fraudulent activity over a lengthy period of time, involving multiple businesses in which she received funds to obtain insurance policies. On March 10, 2021, the district court ordered Taylor-Sanders to pay restitution in the amounts the government requested, well over $100,000. The magistrate judge conducted a proper Rule 11 colloquy as found by the Fourth Circuit. The magistrate judge confirmed that Taylor-Sanders had reviewed the charge with counsel, understood the contents and possible consequences of her plea agreement, and was voluntarily pleading guilty. When Taylor-Sanders twice expressed concerns about the plea agreement or factual basis document, the magistrate judge provided a recess for her to convene with counsel and make any necessary changes to the plea agreement before proceeding. Taylor-Sanders' appeal waiver was valid, according to the Fourth Circuit. The restitution order included $139,847.09 for a year of DW Express's lost profits. Since Taylor-Sanders did not dispute that the Mandatory Victims Restitution Act permits restitution, the Fourth Circuit concluded that each of Taylor-Sanders' claims on appeal are barred by the appeal waiver in her guilty plea. Therefore, her appeal was dismissed. In my opinion, fraud perpetrators have no honor. Even after obtaining a plea agreement that saved her years in prison, Taylor-Sanders took up the time of the district court and the Fourth Circuit to hear a spurious motion to withdraw her guilty plea after knowingly entering into the plea agreement and waiving her right to appeal. She will pay restitution and spend whatever appropriate time the district court ordered her to spend in prison. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And you will have access to the more than 4,690 blog postings. You can also subscribe to the videos on Rumble.com and on YouTube.com, and if you do, I'd appreciate it if you clicked on the thumbs up button on Rumble or the like button on YouTube.com. And if you're interested in further information and detail concerning insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. You could also subscribe to me on Twitter or X at Zalma, at bzalma, and I would appreciate it if you subscribe or follow me on Twitter. Thank you for your attention.